Hello and welcome. I'm Joshua Mack, the Vice President of Marketing and Communications at the Museum of Jewish Heritage, a living memorial to the Holocaust in New York City. And I'm very pleased to welcome you to today's program, The Rule of Law and the Ascension of the Third Reich. Nazi Germany is often misunderstood as an arbitrary, lawless regime. But even as the rule of law was gradually hollowed out, significant structures of the legal system continued to exist. National conservative lawyers and judges contributed in various legal and extra-legal ways to the establishment of a terrorist dictatorship, especially by legally codifying the radical otherness of the racially inferior. Every day, these working professionals made decisions that eroded the rule of law and enabled the Holocaust. In this program, we'll look at their stories and how this happened. The museum is co-presenting this program with FASPE, Fellowships at Auschwitz for the Study of Professional Ethics. The program will be led by Thorsten Wagner, FASPE's Executive Director, and Eric Muller, its Academic Director. Thorsten is Executive Director of FASPE and has been involved with the organization since its beginnings in 2009. He is a German historian who grew up in Denmark, completed his undergraduate studies in Germany, and did his graduate work in Jerusalem and Berlin. The author of numerous academic publications in the fields of modern German and European Jewish history, anti-Semitism, Holocaust studies, cultures of memory, and Israeli history and society. He has also worked as the historical consultant for the acclaimed documentary, Germans and Jews, which dealt with contemporary Germany and its relationship to its Nazi past and the reemergence of Jewish life. Eric Muller is the academic director at FASPE and the Dan K. Moore Distinguished Professor at the University of North Carolina School of Law. His scholarship focuses on the incarceration of Japanese Americans in World War II. His first book in the field, Free to Die in Their Country, The Story of Japanese Americans, Draft Resistors in World War II, which was published by the University of Chicago Press in 2001, was named a top nonfiction title of 2001 by the Washington Post. In 2007, he published American Inquisition, The Hunt for Japanese American Disloyalty in World War II, and an account of the bureaucracy that adjudicated the loyalties of thousands of Japanese Americans during the war. His most recent book, Colors of Confinement, Rare Kodachrome Photographs of Japanese American Incarceration in World War II, was published in 2012 and won the Joan Peterson Kerr Book Award from the Western History Association in 2013. And in 2018, he was honored with the Keith Aoki Asian Pacific American Jurisprudence Award by the Conference of Asian Pacific American Law Faculty. A few housekeeping notes before we start. This program is being recorded and will be available on the museum's website and YouTube channel in the next few days. After the program, we'll be sending out an email with links to FASPE, where you can learn more about their work and other resources. We'll be taking questions later in the program, and you can enter them on the chat function on the Zoom. Lastly, I hope that you will consider a donation or joining the museum so that we can continue to present programs like this. So now I'll turn it over to Thorsten and Eric. Thank you.
Thank you, Josh, for the warm welcome. And Eric, I'm thrilled that we can do this together and that we can talk about some of these topics that in different ways, of course, are really important to both of us. I think that it's fair to say that the way that we've been thinking about organizing this is to start with talking about what we mean by this whole term, what people mean by the concept of rule of law, perhaps both in the European German context and of course also with reference to America, then zoom in on the specific challenges surrounding rule of law and how we ended up with this partial dissolving in the course of the so-called Third Reich, and then also present a little bit how we as FASPE try to deal with this in educational terms, the challenges of the questions of rule of law regarding legal professionals today. And I might also just want to say, Josh already announced that there will be an email going out with the email address, but in case you just want to have a look what FASPE is doing, the email address is very easy. It's faspe-ethics.org. Eric, if I see this correctly, it seems as if there's been a growing interest in this particular topic of law and Nazism, or perhaps law and authoritarian rule, mainly in the course of the last 5, 10, 15 years. I again and again come across references that before that there was not so much interest in it. And the question is, of course, whether this also sometimes has to do with the erroneous perception that law did not matter in Germany through the Nazi period. Question is, of course, that, go ahead.
No, please, Thorsten.
I just wanted to say, I wonder whether the current relevance that some people see, of course, also has to do with the fact that we increasingly do see societies where the executive power seeks to dominate the legal institutions. So without simple equation.
I think in the United States, I think we've been, as the United States is wont to do, we've been mostly focused on ourselves, but it's important to remember that the move towards executive power that we've seen here over the last period of years was preceded preceded us in other countries and continues to roll along. And I certainly think that helps explain some of the interest in the rule of law. I also think it's important to note that, as we'll get to in a moment, that the idea of rule of law is not something that one can just pick up in one place and plop down in another place. It's also not something one can pick up in one historical moment and plop down in a later one or an earlier one. So as always, we have to be careful in the enterprise of analogizing.
Absolutely. And as we try to proceed with care, there are these overarching questions, of course. How can we kind of preserve legal autonomy when the rule of law is under attack? So these are kind of some of the references that we want to make. Let's try to think about how to define this category. I mean, the most simple one is, of course, to say that a rule of law is in existence when we have a state that is bound by law. But I think that we have a PowerPoint that tries to list what many scholars would see as important factors here. Thank you for sharing the screen here, Eric. So typical categories that, of course, are emphasized here is that human rights are codified, that we have, of course, a separation of the three powers within the state and legal structure. The whole point, of course, of restricting state power, state policy, by law, making sure that courts are independent, protecting the individual citizen and society from arbitrariness, from arbitrary decisions. And very often, of course, also there's an emphasis on the quality of the civil service, its focus on the common good and it being incorruptible. Those are some categories that probably, I would guess, Eric, are fairly universal. Probably with different emphasis in different kind of cultural, political, historical contexts.
Certainly. It's important, you know, we're going to be talking about Germany specifically for the rest of this presentation, but I'd like to take a brief detour just to a few little wrinkles of the rule of law as it has played out in the American tradition. And I think this is important because we have to remember that the rule of law, or the Rechtsstaat, as it's referred to in the European tradition, excuse me, particularly in Germany, is very much a reaction at this point to the experience of the Third Reich. And so it's a sort of an effort to achieve a kind of antithesis to what we think of as the lawlessness of the Nazi era. The American tradition, of course, reaches back considerably before World War II, and it's a little different from its various European cousins. For one thing, and I've just picked out a few interesting, I think, notes here of distinction. One of them is how dependent in the American tradition the rule of law is on custom, on tradition, on the ways in which people have behaved, in the ways in which the different branches, for example, of the federal government have gotten along with one another, the ways in which the federal and state governments have gotten along with one another or not gotten along with one another. Much of this kind of moves along, if not fully independent of the vague terms in the Constitution, at least pursuant to a very large kind of supplemental body of ways in which things get done. So we maybe have a little bit less of a tradition of focus on positive pronouncements here in the United States. Another very interesting wrinkle, of course, is that You know, the idea of rule of law, of course, is in service of democracy and democratic control, but many of our core rule of law principles are actually developed by and then sort of regulated by our least democratic branch. That is to say, our courts, and in particular the United States Supreme Court, where our justices are appointed and then serve for life and cannot have their salaries diminished as a kind of punishment for their rulings. So you do have this interesting paradox of the protection of many rule of law principles in the least democratic branch, at least on its face. And then just also to sort of make this first point a little bit more starkly, let's just take the separation of powers, for instance. In the United States, an enormous amount of the way in which the judiciary, and particularly the executive and legislative branches, manage their blended and separated powers is by a kind of quiet agreement that everyone's going to follow the rules. It's not all written down, and it's not all subject to a kind of enforcement through edict. Rather, the branches work problems out themselves. And the reason I mention that one in particular is because one could argue that this is the value that has become most frayed over the last period of years. As the executive has asserted greater and greater power, there is some tear at the notion that these norms and traditions of sort of mutual agreement about how to get along, that might be sort of wearing down a bit. So just a few wrinkles of the American tradition, but now let's head back across the Atlantic to Germany. And Thorsten?
Thank you. Yes, Eric, you already alluded to the fact that, of course, the term that typically in the German context will be used is Rechtsstaat. It's not exactly the same category, especially because it emphasizes the state notion, while rule of law, of course, is not, it doesn't, as a term, not have the same focus. Rechtsstaat, the state of law, state of legality, is actually a composite that developed kind of late 18th century. But before I just, with a few sentences, try to describe what the tradition of rule of law in the German setting was, it's just important to realize that now in Germany, at least for most of the time, West Germany, we've had these 70 years of a successful Rechtsstaat, of rule of law and democracy. But of course, when people think of German history, one of the first things that come to mind is, of course, the very checkered, problematic history of democracy regarding Germany. And that's where it's interesting that on the one hand, democracy was such a difficult birth for Germany, while there is a fairly strong tradition of rule of law that goes back much earlier. As I said, term, concept, coined around 1800, it becomes the rallying cry for what you in the 19th century would think of as the liberal pro-democracy bourgeois forces who demand parliamentary democracy, constitutionalism, the separation of powers, civil liberties. That fails, as many of you know. In 1848 it culminates, but in the end we don't have a successful democratic revolution in Germany. But we do end up with a rule of law that also governs the remaining decades of the 19th century and early 20th century. But now the term takes on a more formal, perhaps less politically specific character. So what people think of then is it's a state governed by law, it's neutral, it creates predictable procedures of government, of administration. And there are some scholars, Michael Stolleis is one of the leading ones, who emphasizes how, to some degree, rule of law as an idea and as a practice becomes something of a substitute for political democratic participation, which was never achieved. The last point that I want to make about Germany for now is we should just keep in mind that Germany is a little bit of an outlier for all kinds of reasons, but also because of the reason that we've had these manifold radical changes of political and constitutional systems, depending on how you count. We're talking about 5, 6, 7 systems from the empire into the so-called Weimar Republic, the first attempt as a democracy after World War I, into Nazism, then a short period of occupation by the Allies, and then West-East Germany and then United Germany. And each time, of course, it's legal scholars, judges, lawyers who had key roles in the process of reinterpreting the whole legal order, the legal system. Even statutory law, of course, in that context. And I think that's worth just keeping in mind when we zoom in on the specifics of the Third Reich. Talking about Nazi Germany in that context, I'd like to just raise one important point, and that's, of course, that there's a tendency of a certain, perhaps two interwoven misconceptions. One is, of course, that we think of Nazism as the ultimate collapse or absence of morality, something that I'll come back to. And secondly, a focus on the Nazi regime as tyranny, characterized by arbitrary rule and enforced through intimidation and terror. So first and foremost, lawlessness as defining moment. And I think that's worth just considering and pondering about that notion, because to be sure, the Third Reich started with a state of emergency, whether we want to define January 30th, 1933, with Hitler coming to power as that moment, or the legal changes right after the arsoning of the parliament of the Reichstag in Berlin. And to be sure, again, Germany in the 33-4 is no Rechtsstaat, doesn't have a rule of law in that way anymore, because we do see that through measures implemented outside of the framework of traditional codified German law, millions are deprived of their property, of their freedom, of their lives. But the punchline that I want to discuss for a moment is, of course, that nevertheless, we do see a legal system that continues to function, that still is recognizable. And that, of course, means that we do see a formal administration of justice that increasingly is dependent on political dictates. Biological racism is gradually integrated into the legal code, and judges, prosecutors, and the civil service accommodate themselves to this interference, something that probably also Eric will touch on a little bit later, the role of the individuals in that context. And we do see a power struggle even between the more ordinary administration and the new organizations being more powerful now, whether it's the Nazi Party or the SS. But nevertheless, we see this kind of ambivalence that we have to get into. What I would like to focus on for a moment is, of course, perhaps 2-3 different factors. One thing is the legal theory that changes, the jurisprudence. There's a wonderful quote here. I think it's a Hans Frank quote, who says, law is what is useful to the German people. Injustice, Unrecht in German, is what is harmful for it. So that's obviously a very different understanding of the sources of law. So what these legal scholars in the first month of Nazi rule make very clear is we reject this whole formalism, positivism, liberalism that has defined the notions of rule of law in the Weimar Republic. We want to find a way to fuse the idea of justice and the reality of statutory law. And this is probably the most important punchline, I believe, for larger parts of our conversation today. We want to fuse the two normative spheres of the law on the one side and morality or ethics on the other. And how do they argue? They argue that what is going to be the connective issue is, and I'm going to use another German term here, the Volksgemeinschaft, the racial national community, which is going to be this binding together, which of course in Nazi thinking was born out of the experience of World War I. That has the implication that ethical concepts such as moral duty, decency, honor, loyalty now become legal terms. It means that this national community, this Volksgemeinschaft, becomes the ultimate source and principle of law, of course, against the liberal emphasis of individual freedom. And it means, of course, also that kind of safeguarding the purity of the racial community actually becomes a legal requirement of the first order. The way that this is then put into practice, and that's the second part that I just wanted to raise regarding the German setting, is that in the mind of those redefining the legal order, there's no room for civil liberties anymore in the Führer state defined by Hitler and by the national community. And in many ways, of course, what the legal scholars do is that they retroactively legitimize one of the most important ordinances that is made basically a legal document, and that's of course the so-called Reichstagsfire Ordinance. On February 27th, 1933, the Reichstag is put on fire, and most likely the Nazis were not involved. That's a whole different discussion, but the important thing is here they used that as an opportunity, moved fast, and abolished freedom of speech, freedom of the press, freedom of assembly, of association, the right to vote, the secrecy of correspondence, very much the whole kind of structure of civil liberties was put down by this juggernaut of the Reichstagsfire Ordinance. And the argument was these civil liberties only had a purpose in the 19th century and in a state with a monarch, but in Weimar they had led to chaos. And now with the having a state where Hitler is the Führer, as the center, we don't need them anymore. He is embodying the law, we should get rid of them. Now the punchline here is, of course, it's not necessarily only Nazi laws who actually get rid of this idea of individual liberty. It's actually very much also these legal scholars who have a central role in that. It's jurisprudence itself that is a key player in destroying the idea of individual liberty from the inside. Now, before we move on and look at how to try to get a sense of the decisions of lawyers, of legal professionals that Eric, you will focus on, I think it's important just to get one fundamental ambivalence clear. And that's, of course, an ambivalence where we, on the one hand, see that the Nazi regime abolishes the separation of powers and the parliamentarism and all these other factors I just mentioned, this whole so-called Gleichschaltung, the synchronizing of all organizations. They reduce the legal protection from the law. They abolish administrative jurisdiction on the one hand. But on the other hand, Nazi Germany cannot really be described as an arbitrary regime per se. We still have a rule that is established by properly issued laws and by administrative decrees, and a lot of even the exclusion and persecution and terror against Jews, against other groups in German society happens through laws, decrees, and ordinances. And I think that we have a list of examples here that give us an idea of the role of these ordinances in that context. We have some examples here that very much also have to do with this early process, but just think of that whole stretch of years, that whole period, as one long list of laws, decrees, and regulations that first and foremost, but not only, of course, drive Jews from all kinds of positions in government, education, media, arts, economy, social, cultural life, and so on. So that's, of course, one of the main focus points. Now, that speed of that transformation was, of course, only possible because the middle-class elites, the professionals in the legal system, but also in the bureaucracy, in the military, were willing to cooperate. But the important thing is, of course, here is that even within the legal community, and even when we look at the lawyers, at the judges, there are some even dedicated Nazis who are disturbed by this deviation from the rule of law. Some of them even go so far and want to stick to this concept of the Rechtsstaat. The point here is there's not a controversy whether Germany should be a racist dictatorship. They agree on this. But they disagree on whether this racial order should be maintained by law or by the arbitrary exercise of power. And that's the tension, basically. There is a famous scholar, Ernst Fraenkel, who has probably contributed the most to our understanding of that tension. Ernst Frankl was a lawyer, probably to be defined as socialist in his political views, had been in World War I, was persecuted as a Jew in the 30s, but continued to work in Germany as a lawyer, also because he had been in World War I as a veteran, and then goes into exile in 1938, and eventually publishes a book that is called The Dual State. And that term already is, of course, the most important help for us to understand that simultaneous existence of a traditional legal system and this extra legal system of terror, how we can have these two parallel spheres of official authority. So what he means is he, on the one hand, sees a prerogative state because he can see the courts continue their normal operations in some areas. And then he defines that in juxtaposition to the normative state. So obviously the normative state will be the courts, the traditional legal order, and the so-called prerogative state is that part of the governmental system, but particularly also these new institutions that, of course, exercise unlimited arbitrary power, controlling the freedom and lives of its subjects. And that sets the frame, arguably, for the decisions that lawyers and judges have to take in this process. Eric, can you help us understand that specific challenge?
Yeah, I'm going to mention a specific case that I think shows this inflection point that you've been talking about, where the prerogative state is rising and the normative state is atrophying, I guess you could say, but still present. I just wanted to mention that if you think about it at the level of the individual professional, the individual practitioner, it was arguably precisely the survival, the maintenance of this normative state, of a court system, of a system of regular prisons, of a system of regular administration of civil law that is very much a carryover from Weimar. It's that very maintenance that is one thing that enables German lawyers and judges to continue along. You know, the world is changing around them, but it's also staying the same. And many of the institutions that by which they identify themselves, both civil institutions and also professional institutions, continue to be present. I think that's an important thing to remember. I think it's so easy to think of January 1933 as being this moment when a kind of dark curtain descends over Germany and all of its people, and all of a sudden we're transported into a different land. But that would not have been the experience really of sort of the average non-Jewish German lawyer, certainly at that time. And I mentioned non-Jewish German lawyer because there's another thing I think we need to think about when we think about the complicity, the early complicity of lawyers in particular. Or either their outright complicity or at least their silence. And that is that by 1933, the practice of law, the legal profession, is vastly oversubscribed in Germany. Vastly, way more lawyers than there is work. The result of that, of course, is that, and I have a slide from a different presentation, which I didn't think to put in here, but by 1933, the average attorney in Germany was making less than a bricklayer. And something like 10% of the German bar for the year 1932 reported no measurable income at all. So if you think about this and you try, as hard as it is, to imagine yourself into that world, if a regime comes along, one of whose promises is to curtail the size of the bar in significant part by exiling its Jewish members, of which there were disproportionately many, however morally troubling this might have been to a person, it also had certain economic appeal. So those are important things I think to keep in mind. This is not certainly by way of justification. It's simply by way of explanation. The story I wanted to mention that illustrates, Thorsten, your really apt depiction of this kind of ambiguity, or this ambivalence in the early days of the regime, is the story of Josef Hartinger. And it's a kind of story that I think the average person who really has done little reading about this time period and place thinks ought not to be possible. What had happened was, after the Reichstag fire and the burning, and then the law, the decree that was put in place, there were mass roundups of individuals, and these mass roundups were not done pursuant to ordinary order police procedure. In Bavaria alone, there were something like 10,000 people who came under arrest in the month of March, which meant that there was no place to put people. They had way more people under arrest than the normative state's capacity could handle. So all of the jails were full. That when I say the jails, I'm not talking about concentration camps. Now I'm talking about the conventional jails. They were all full. The new regime was putting people into schools, was putting people into music halls and sports halls because there were just so many. And it was this pressure that led to the establishment of Dachau, which you see on the screen here in a very early shot of it. It was an abandoned munitions factory that was taken over, and in a way, as in part to siphon off of the pressure off of the organs of the normative state, people were dumped here, especially this new breed of, political prisoner, political opponents to the regime are just dumped here without legal process. That is to say, without the conventional process of the normative state. Dachau at that point was run by the state police. And the state police took account of the situation confronting them, which is to say, they are civil servants who are supposed to be applying the laws of the normative state, which still exist. And they're overseeing all of these arrested people as to whom there are no legally recognizable charges. So the state police protest. They object to these duties, and they are relieved of those duties quickly. And the SS come in. About 120 SS members come in to take over the administration of Dachau and also the guarding functions. And pretty much the very next day, killings begin. In particular, there are 4 killings of individuals who are, it is stated, were killed while trying to escape. But we learn otherwise. Why do we learn otherwise? We learn otherwise because of the man on the right of the screen. This is Josef Hartinger. He was a deputy prosecutor in the normative state jurisdiction called Munich II, which was basically it was the administrative district for the rural regions that surrounded urban Munich, right? So it was not Munich proper, the city, but it was the surrounding, the outlying areas. Dachau geographically is within his jurisdiction. It is reported to him that killings have deaths have occurred at Dachau. So he does what a civil servant does. He grabs his coroner for the district, and they go over to Dachau, and they go in and they demand to see the bodies. They see the bodies, and they find that these escaping prisoners all have bullet holes in the backs of their heads, which would be an unlikely scenario for people who are being shot while escaping. The coroner examines the bodies, finds a lot of evidence consistent with a kind of extra-legal killing. They are very concerned by this, Hartinger, the prosecutor, and his coroner. They go back to the office, and over the next few weeks, they hear about more killings. And every time they hear about a killing, they go back to Dachau. The SS are not happy to see them there, but we're in this world where both of these states are ambiguously residing sort of beside and on top of one another. And so they let them in. And to make the long story short, Hartinger ends up drafting indictments, criminal murder indictments against the commander of Dachau and a couple of his top executive officials. He submits it to his boss for validation. The boss refuses to sign it. The boss has decided that the SS is already too worrisome. But he says to Hartinger, if you're so convinced of this, why don't you sign them? So Hartinger signs them. He goes home and he signs them and he tells his wife, I've just signed my own death warrant. He submits them, and this is where things get very surprising. Like ordinarily we would assume, well, what happens to Josef Hartinger? You know, the SS get wind of it and he is then taken out and shot. But that's not at all what happens. What happens is they're placed into a desk drawer. Himmler at this point has come into control of the administration of Dachau in a more thoroughgoing way. They put the indictments into a drawer. Hartinger is reassigned. He's reassigned to a rural district, and he lives out the rest of the war in safety, or I should say the rest of the time period in safety. This, I think, is a wonderful illustration of the tension that existed in this period of time in 1933 when both of these states were in coexistence and one was coming to supplant the other. Thorsten, you may want to say a little bit about this idea of how otherness gets codified in this period.
Absolutely. So our main goal for the remainder of our time is, of course, for us to illustrate a little bit how FASPE is working with using these kinds of historical references for a challenge of contemporary or young professionals. But before we get there, I just want to mention one last thing that actually still, for me, is always what really stands out. And that is that, of course, there's a connection between that process of the change of the understanding of legal codes and the ethical and moral aspect that we already related to in this context. There are two guys that really have helped us understand this. One guy is called Raphael Gross, the other one is Harald Welzer. And their point, of course, is to make that, that if we look at 1933, just again as a starting point, and at these kind of laws that we mentioned earlier, we have the idea of a radical redefinition of who belongs, who is part of the community, who is part of the German folk, the nation, and who does not belong. And that is redrawn, but it's also codified. It becomes set in stone. It becomes part of the legal code, of course, which brings us back to that simultaneity, which means Nazi law was based on a system of moral and ethical values that might be reprehensible to us, but by the Nazis themselves were seen as virtuous and altruistic. And again, categories like honor, loyalty, comradeship, decency, which of course exclude Jews from this moral universe. And I think that's extremely important, just always to keep in mind and ask oneself, how could it be that a modern Western society with some kind of Christian background in such a short time could change into a radically exclusive society so fast that even non-Jewish Germans did not notice these changes in their normative orientation and were completely capable of reconciling their inhumane attitudes with their images of themselves as moral beings, seeing themselves as good people. So even after all these years that I've been trying to understand and deal with Nazism in this context, it still challenges me to understand how in such a short time groups can be excluded from the universe of a civil society, from a universe where we have norms such as justice, compassion, benevolence, which are still in force, but no longer apply to those who by definition are excluded from this community. So it's not just a society that is unjust and despotic. The injustice and despotism affect the non-members almost exclusively, while the German folk continue to enjoy legal security and state welfare. And I think that distinction is extremely important to understand that rapid change of norms, of laws, and of morality in these years.
I know that we have, we're going to have an opportunity for some questions and discussion, but I did wanted to sneak in a little bit here about FASPE here at the end of the formal presentation, to try to give the audience a little bit of a sense of what's distinctive about our approach to professional ethics education and Holocaust education. The headline here is, the thing that we are not is an analogy organization, right? So we are not in the business of holding up policies of the 1930s in Germany, or the 1940s for that matter, holding those up against American policies in the 1960s or in the 20-teens or in the 2020s, or that's not what we do. Our way into this, the reason you see professional in there and professional ethics, is that we think the interesting point of contact is at the individual level, at the level of individual human beings, individual professionals, whether they be doctors or lawyers or journalists or others. Is it possible to imagine oneself today in one's life as a professional and learn something about one's own professional development from the way in which complicity unfolded in the 30s, from the motivations and influences that touched on professionals in that time? That's where we feel that we can really use this history in a way that is relevant in a contemporary way. And I'll just give one, I'll end with one very quick example here. This is a headline of an op-ed that appeared in the Washington Post back in January of 2019. It's by a young lawyer named Erica Newland. She had at that point joined the Office of Legal Counsel, which is arguably the most prestigious office within the Justice Department, responsible for developing, opining upon and developing the legal rationales for executive action. She was in that office. She came into the office before the election of President Trump and then stayed on into the new administration. In this startling op-ed piece she published after resigning in protest, her position in this op-ed was that she had, over the period of months that she was in the office, increasingly found herself expected to provide factual grounding, factual bases for executive action that was either unsupported by evidence or outright manufactured by the executive. She tried to hang on for as long as she could, but she reached a point where she felt that she could no longer, in good conscience, continue to provide these jury-rigged factual justifications for executive action, like, for example, the so-called travel ban or Muslim ban, which is the Supreme Court case that you see down there in the bottom left of your screen. The idea here is that individuals within a system, and it doesn't need to be a government, it can be a corporation, it can be a law firm, it can be a hierarchy of a medical team, are presented with individual points of decision. And it's through that look back and looking at the temptations and motivations and seductions of that time period 70 to 80 years ago that we might learn something if we can make ourselves uncomfortable enough and live with that we might learn something from looking at those earlier professionals. That's the FASPE idea. And I think we can stop there. I don't, Thorsten, did you have anything further that you wanted to say about FASPE before we?
I think it's probably a good idea to take some questions.
Sounds good. I will end the slideshow. Just a moment. Stop the sharing here. All right. so I'm not sure whether I think Josh will come back and
I'm back.
There he is, like magic.
Thank you, both. There are some very interesting questions coming up. So one question from Andrea is, how did this view of otherness influence the medical profession in the Third Reich and its implementation of the T4 program, which when the museum reopens is featured in the Auschwitz exhibition quite a bit. So you want to take that on?
Thorsten, that sounds like a question for you.
I would say it's deeply connected because, of course, a lot of the definition of who belongs and doesn't belong is based on notions of biological categories. And of course, that thinking then goes to both exclude people on the basis of biology, but of course also affects medicine as getting a new task. Medical professionals are not anymore focused on the individual and the rights of the individual patient, but are now taking care of the national community, again, the Volksgemeinschaft. And of course, Josh, you refer the so-called euthanasia program, also known as T4, which of course works under the umbrella notion of removing and murdering the lives not worth living. Right, so the idea to define people who are sick, people who are handicapped, people who, quote unquote, are retarded as one of the concepts, the terms that are used by people in the 30s and 40s, and then take these people who just are a burden on society in the Nazi perspective, and either by forced sterilization or, of course, eventually also by murder, to implement that in the medical context.
Thanks. Monica asks, can you comment on the importance of the SS, the existence of a police military entity that cooperated with the change of the legal codes? Was the SS formed using legal rule of law vehicles and then used to force acceptance? And without the SS, would these changes have happened? Interesting.
Eric, do you have a take on that?
I'm going to, as the true historian of this era, I'm going to defer to you on that. I may have a thought after you've spoken.
As it was founded in 1925, and of course predates some of these processes. But that being said, both the domain of the SS, which soon after 33, particularly after 35-6, will be the whole world of the concentration camps, and then of course particularly the areas in the quote-unquote East, the conquered areas. The whole both geographic and political sphere that is created and under control of the SS becomes, of course, the ultimate place for the prerogative state and for the prerogative powers. So I think that's really where the cancerous growth of the idea of prerogative powers and genocide under the rule of these institutions become visible.
I'll just note that as startling as it may seem, it's important to remember that there were quite a number of people with law degrees in the SS. The SS was not, and was populated in part, at least, by lawyers, perhaps in small part. And in fact, one of the individuals at the notorious Wannsee conference, who had just, in 1942, who had just flown in from the mass shootings in Latvia, Rudolf Lange was a man with a law degree. So these worlds overlapped.
Interesting. There's actually, Nate asks, with regard to the famous tribunals, like the, I'm going to mispronounce this, the Volksgerichtshof, did it function more as a way to intellectualize murder for elites, or was it more of a show trial designed to instill fear across the greater populace?
I'm thinking more the latter than the former, Thorsten, but you may have a different view.
I mean, for me, the Volksgerichtshof and Freisler, Robert Freisler, who's of course the head of that, since 1942-43, really is the embodiment of the encroachment of the prerogative state over the other institutions of normative orders, and basically it changes the balance in many ways. Yes, with the ambivalence that it's still a court, but it's of course a court that doesn't even try to keep up the appearance of some kind of even-handedness or kind of correct procedure or anything like that.
Marion Kaplan asks, does the normative and prerogative distinction hold beyond 1933, or is the normative state sullied by the prerogative state?
Could you repeat that?
Does the normative and prerogative distinction hold beyond 1933, or is the normative state sullied by the prerogative state?
I mean, I can offer a piece of an answer to that. Germany continued to be a fully functioning political entity throughout this time period. So it needed institutions that were not involved in mass killing, right? People got divorced. People got divorced in Nazi Germany. People changed their names. People, there were all manner of continued civil government things that continued, and those continued at least under the form or the format of a normative state. You didn't walk into to a court and a judge would simply be able to determine whether the Führer would want you divorced or not, right? I mean, so there was at least a shell of a normative state that continued. But I think, Thorsten, maybe you might say another word about this. I think that increasingly in 34, 35, that becomes more of a shell. It gets hollowed out and staffed more and more by individuals who are either actively or at least passively complicit. But Thorsten, does that sound about right to you?
Yes, absolutely. I mean, in the question, of course, there's built in the point that the prerogative state expands. And it's the way that Ernst Fraenkel, I think, convincingly describes it is, of course, that the normative state exists at the whim of the powers of the prerogative state, right? So this is not equal. And okay, let me also add the idea, whether Ernst Fraenkel back in the 40s or a scholar 80 years later uses these categories, they of course attempts at interpretation and categorization. It's not as if the Nazis say, let's have these two systems parallel, right? It's a way to try, with all its shortcomings, a way to try to analyze a confusing reality, even a confusing reality for the contemporaries. But yes, the way I understand it, it's not limited to 1933, it continues to exist. And if I read the scholarship right now correctly, thinking of people like Jens Meyer-Henrich and others, there is even an argument to say we need Ernst Fraenkel's analysis, and we need to look at what happens in Nazi Germany in the 30s and even early 40s to understand that we can have a combination of some kind of rule of law combined with an authoritarian regime, that these things actually, with all the tensions, can coexist. And I think that's an important insight, again, without the analogies, to sharpen our perspective on our time that we live in right now.
The comment feeds are getting quite heated about analogies, and given that guidance, I think staying away from them. There's a question from Zach about, was the general public convinced by the government that its decisions against outgroups were within the normative laws, or was there a willful blindness on the part of the general public, or were they perhaps coerced to conform? Does that make sense?
Thorsten,
I understand it, I was hoping that I understood the question correctly, is of course that there was only a minimum of coercion against the border part of the population because they were part of the in-group. So in other words, already in 1933, the community is created on the basis of violence, right? We can see violence against the other, we can see violence against people who are defined as communists or social democrats, or particularly Jews, of course, in these early months of the regime. So violence is a constitutive element of Nazism from day one. But at the same time, the Nazi regime, of course, constantly tries to contain that within some or to some degree, and to make sure that those who belong, those who are inside, continue to live a life that is defined by a relative degree of physical safety and legal certainty. That's, of course, the punchline that I talked about earlier. And it's that kind of main part of the German population that doesn't need to be coerced because they share these values increasingly. There's, of course, this kind of gradual change of values, of normative perspectives in the course of the 30s that I think is one of the most important features, and that eventually, of course, will make people participate in crimes in 1942 and 3 that they didn't imagine that they would be able to do just a decade earlier.
Thank you. There is a question in here about, is there evidence that Nazi Germany based any of its laws on the American eugenics movement and the Jim Crow laws of the 19th and early 20th century, which I will say will be the subject, hopefully, of a future museum program. But if you have any thoughts on that, I would.
Yeah, so I'll just speak very briefly to that. There's a wonderful book that came out a couple of years ago now called, I think, Hitler's American Model, I think was the title, by James Whitman at Yale, which documents, I think, quite persuasively that influential German legal scholars were looking carefully at American eugenics and also segregation laws as models, at least for the portion of German race law that had to do with marriage and intermarriage. There's no question that they were deeply aware of the state of American race relations at that time. And it really, in a certain sense, stands to reason that a country or a regime like the early Nazi regime would have looked to a contemporary. I mean, you know, in 1935, it was impermissible for a Jew to sit on a bench with an Aryan, or 1936. That was also true here in Chapel Hill, North Carolina, where I am sitting right now. So there would be ample reason to see and imagine a connection there.
Thank you. And I think to close, and
I'm sorry, let me clarify. The bench thing would have been a white person and an African American, not a white person, not a Jew. Yeah.
Of course. Was there anything, he's asking more contemporary, but was there anything that an ordinary citizen could do then to hold the government and legal system accountable for unethical behavior? Or was there any actions that a German citizen could take in the time?
Well, I mean, I think that you know, we can look at the Hardinger story there as just emblematic of the fact that many people within German society retained what the legal philosopher David Luban has usefully reminded us, a German term of Spielraum, or room to maneuver. That remained present in people's lives. So being a professional or just being a German at that time, to the extent that you were aggrieved or concerned about the direction things were taking, your life might have been seen as a constant series of little choices about exercising whatever little bit of latitude you had in terms of how willingly you did something. Whether you tried to figure out a way to slow something down a little bit. The idea that everybody who in any way resisted or slowed things down or impeded things was lined up against a wall and shot is a gross misunderstanding of the way that society actually ran.
I think that's a perfect way to end things. Little actions. So thank you both so much.
Pleasure.
And again, everyone here will receive an email with a link to this program and links to FASPE, which does such amazing work. Thank you all for joining us.
Thank you, Josh.
Thanks.